the case entitled Carl LaShomb versus Willie Jane Patry, case number 24 AP 048. Representing the appellant, Willie Jane Patry, is Jacob Oblock. Representing the appellee, Carl LaShomb, is Jennifer Agnew.
Thank you very much. Good morning, counsel. We'll hear from the appellant. First, of course, please identify yourself and your client and then proceed.
Thank you, Your Honor. And may it please the court, my name is Jacob Oblock, and I represent Willie Jane Patry, the appellant in this case.
Thank you.
Thank you, Judge. This appeal comes to this court from a final order adjudicating parental rights responsibilities and parent-child contact. And this was a case the trial court determined was a closed case. In such cases, this court's guidance has shown that the trial court's findings and conclusions are vital to this court's ability to review the trial court's decision. Here, two were erroneous, and the trial court failed to adequately weigh the factors or adequately explain its analysis sufficient to enable this court to review that decision. I'd like to begin by addressing a couple of appellee's arguments first. First, appellee argues that nobody raised abuse specifically below. Now, this is inaccurate for three reasons in our view. First, one does not have to plead abuse with specificity as one does with fraud, and no one needs to make legal arguments at a final parentage hearing, summarizing the evidence, if you will. In fact, that rarely, if ever, happens. The issue of abuse is raised every time somebody files a parentage action or a divorce complaint dealing with minor children, because the legislature has seen fit to provide 9 factors that the court analyzes when adjudicating those requests for parental rights and responsibilities.
The legislature's also made it clear that if the parents can't agree on parenting, that one parent's in charge. We don't have a presumption of shared parenting being in the child's best interest. We have the opposite of that. And that the parents can't agree on things, then somebody needs to make the decision. And this was a case that I've always found to be the most difficult. We have 2 very committed parents, and that it's going to be it's a close case, complicated by the age of the child, which is an interesting component to this because of the way sometimes teenagers act with parents.
I think
the question in there someplace, Mr. Oblock.
I'm happy to respond to that, Your Honor. Those are many fair statements in there. This is a closed case. Obviously, both of these parents love this child. The child's lucky to have the parents. I don't think anybody disputed that below. I also agree. I agree with Your Honor that, again, there's a lot of evidence that comes in these sorts of hearings, and the trial court does need to make a decision. I think, though, that this court's guidance has been pretty consistent over the years, over the decades, that the trial court needs to explain its analysis sufficiently. And here, I don't think that there's any problem with the legislature's provision that there are 9 factors that the trial court looks at, and all 9 of those are at issue, if you will. They're all raised when somebody brings a parentage case to the trial court, because the trial court is statutorily required to look at the 9 factors. So that's one of the reasons why the trial court had to decide whether abuse was an issue. The second reason why the statement that nobody raised abuse is inaccurate is mother testified as to father's behavior and father testified to his behavior, and that gave rise to questions about Factor 9 as defined by Title 33, which I'll get to in just a moment. But that in the evidence, the issue was raised. And lastly, abuse was certainly raised with specificity, even though that's not required in the motion to reconsider. So there are 3 reasons why that question is live before this court. It's not precluded by a failure to raise it below. Secondly, again, there's a question of whether Title 33 looks at someone allowing a child to spend unsupervised time with a registered sex offender as abuse under 4912's definition of such. And the analysis that appellee appears to look at—
You have 1 minute, counsel. You have 1 minute.
Thank you, Judge. Is actual danger. That's referenced in appellee's brief. However, actual danger is not the statute. It's risk of harm. And risk of harm, again, has the definition that includes spending unsupervised time with a registered sex offender. So this court could decide whether, again, the legislature intended a presumption or an inference, if you will, if that's happening. Rebuttable, of course. We agree that the facts would be paramount in determining the risk level. But the trial court here didn't even engage in that, and appellee doesn't seem to indicate that she did. So for many reasons, including those listed in the brief and those argued today, we believe this court should reverse and remand so the trial court can provide that analysis. With that, I would reserve my time.
All right, thank you very much. We'll hear from the appellee now. Please introduce yourself and identify your client, then proceed.
May it please the court. Good morning, Your Honors. I am attorney Jennifer Agnew, and I am representing the appellee, LaShomb, in this case. What I think this appeal is really about is a request by the appellant for this court to basically reassess and reweigh the evidence, which this court may not do. The discretion here is limited. The findings of the trial court should stand unless they are clearly erroneous, and they're only clearly erroneous if there is no credible evidence to support them. So even if there is substantial modifying evidence that may support the appellant's argument, that's not the standard under Mullen v. Phelps. It's no credible evidence. In this case, there was plenty of credible evidence that supported the court's decision, the appellee's argument in this case.
And Ms. Agnew, Justice Cohen, did you want to go ahead first?
No, I'll defer to you.
Okay, thank you. And Ms. Agnew, Father testified, didn't he, that the person who was the registered sex offender who Father permitted the daughter to be in the presence of was an employee or a former employee, and the conviction was over 30 years ago, was it not?
Yes, Your Honor. Briefly, the conviction was 30 years old. Both parents knew this person very well. He was a tenant and remains a tenant as of the date of trial of Mother's. So he rents a place from Mother. He was an employee of Father's. The child had spent time unsupervised in both parents' households, not hours upon hours. Sometimes she caught a ride between households with this person. There was never any concern. That was a testimony at court until the status of this person was discovered. My client testified he'd known him for a long time. He checked with the child. He had no concerns. The appellant felt differently. And in response, my client fired this person as of August of 2023. So that was 3 months before the date of the trial in this case, and had barred him from being on his premises. So regardless, this whole matter was resolved as of the date of the hearing and had been for at least 3 months.
And there had been no allegation of reoffense by this person, correct?
There's no testimony as of that. Neither party testified about that. Ms. Patry testified that before she realized what his status was, she had no reason to be concerned about him in the child's care. So I do want, the court did state, factor 9 is not a factor here. I believe that the case law requires the court to consider all factors that are relevant. So I think it can be understood that the trial court did not find that factor to be relevant. And I believe the court also had findings that support that determination. And what the appellant is asking for is that be reweighed and reassessed. And I don't think that is permissible here.
How much weight should the trial court give to the testimony of the child, the 14-year-old woman, and who states a preference?
Well, Your Honor, I don't believe that question is raised on appeal, but I'm happy to answer it.
Sure.
How much weight did the trial court give? It appears to be not that much. The trial court stated all the factors. It didn't do it specifically. Here's what I think about this factor, but I think from my brief you can see that there were findings on each factor. And then as part of its conclusion, the court also notes that the child has been asking to reside with Father. I think in the context of this case, given this child's age, how each parent approached that request had to do with their ability to the developmental standard to meet the child's developmental needs. So you have
1 minute, counsel. You have 1 minute.
Thank you. One parent says this child is 15. I think she should have some say in where she lives and where she goes to school. I think we should try it out. He testified that if she didn't like it in the school system, he wasn't going to be opposed to her going back. The other parent was frankly more rigid. We know best regardless of age. I know best. And the court had to look at those two competing, parental philosophies and make a decision. And I think there was sufficient evidence to support the court's findings and conclusion of law in this case. I think that the decision should stand. I have nothing
Okay. All right. Thank you very much. How much time does the appellant have, please?
Appellant has 11 seconds remaining.
Counsel?
Thank you, Judge. I'll be very quick. We disagree that there was any credible evidence of any unsafeness at the aunt and uncle's home. There were hours back and forth between New York and Vermont via travels, unsupervised with that sex offender. And with that, we would rest, Your Honors.